Hello, my name is Tracy Leroy, and I'm a Child Advocacy Manager in the Escambia County office. I've been with the Guardian Ad Litem program almost 11 years. The topic that I'm going to be discussing today is information gathering and report writing. You will be gathering information for your child visitation reports as well as Guardian Ad Litem reports that will be filed with the court. That information is very important so that we can be ensured that we are providing the court with the most recent information involving the children and the families that we represent. There are three very important things that each volunteer must remember. You need to visit your children at least once monthly. You need to prepare a visitation report and make sure that that information is given to your child advocacy manager each and every month so that we can ensure that all of our information is up to date. The first part of the topic that I'm going to discuss is information gathering. There's some basic general information that you need to gather at your initial visit. The full address of where you're visiting, as well as a general description of the home, the condition, and the cleanliness of the home. You'll need to gather the names and the relationships of all the people living in the home, as well as how many bedrooms they are, what the children's sleeping arrangements are, and any provisions that are being made for the child's basic care. If you're coordinating visits with a caregiver or a foster parent, you need to make a mental note of their work schedule and the child's school schedule so that you can come at a time that's most appropriate or as easiest for all of the parties involved. Arrangements for the provider and the child's daycare is also information that can be gathered if it is applicable. Another very important topic that needs to be covered in each and every visit is if you have school-aged children, any academic information that you can gather. If the child has medical conditions that we need to be concerned about, that information needs to be gathered as well. If there are any special services that the child is receiving, you need to document those services and the name and contact person that's providing those services. If the family is receiving financial assistance, or if the child is receiving Social Security benefits, that's also information that needs to be gathered. Very important things to look for during your visit: the interaction between the child and the people in the home, particularly if the child is placed with parents. If the child is not placed with a parent, you need to talk to the caregiver regarding the frequency and the amount of time that the child is visiting with the parent, and if the child's behavior changes when visiting with the parent or after the parent leaves. If the child is separated from siblings, you also need to ensure that you know how often the siblings are visiting and if the child is having contact. Subsequent visits, when you do your second or third visit with the home, you want to follow up with all of the information that I just gave you previously: the child's health status, any update on counseling services, the child's visitation status with parents or siblings, as well as the parent's case plan compliance if you are visiting with that parent. If the child wants to talk to the judge or have any information passed on to the judge, you might want to document the child's feelings or comments so that it can be accurately conveyed to the court. Next and first, we have a Guardian Ad Litem report. This is what we're going to be talking about. This is the information that has to be provided to the judge at an initial judicial review hearing to let him know how things are progressing in the case. This slide tells you the heading for the case: the child's name, information that identifies this case from all the others, who's preparing the report, the type of report, the case plan goal, and the amount of time that the child has spent out of the care of the parents, if that's the case, and the number of placements that the child has been in if he's not residing with his parents. Next is the most important part of the Guardian Ad Litem report. The judge receives a lot of information on each and every case for every hearing. So we'd like for the judge to see the recommendations that we're making up front. So we put the recommendation section in the beginning of the Guardian Ad Litem report. In the event that the judge doesn't have the time to read the whole report, he has what we're asking for up front when making his decisions at a court hearing. We want to make sure that we cover the placement, where the child is residing, if that placement has changed, how the child is doing in that placement. If there are additional services that the child needs, we also want to list that. any visitation that's occurring between siblings, parents, how that's going. If we're going to recommend that it increases or decreases, that also needs to go into that section. Permanency, that is the case plan goal, and if we're on target in achieving that goal. Next, we have the child's wishes. You can indicate if the child has a desire to be reunified with a parent or to continue living where they're currently living, or if there are any additional services that the child thinks that they might benefit from. That is where that information will be placed. All children are invited to participate in court hearings and can speak to the judge at any time that they desire or choose. But if the child cannot be in court or does not want to be in court, we can include that information in our guardian ad litem report. The next section is the timeline to permanency. We just kind of want to give the judge an idea on when the case started, when the children were adjudicated dependent, when the case plan was accepted, and when the case plan expires. That gives the judge a timeline to ensure that we're staying in line with the standards set by the legislator to get children in a permanent placement in the time allotted. That information also appears in almost every other document that the judge receives, so it gives him an opportunity to stay on top of things. The children's status, again, is a reflection on how the children are doing in their current placement, their educational goals, if they're being met, and any medical or any other type of assistance they may be receiving. Sources contacted or consulted. It's very important that we provide the judge with the information or the names of the parties that provided us with the information that we've included in the report. In the event that we have to have a trial or these folks need to be contacted to provide firsthand information to the court. And lastly is a summary that sometimes discusses how the parents are doing, how the children are doing, and what the guardian ad litem would like to see happen going forward. The guardian ad litem report is signed by you, the volunteer. Secondly, by the child advocacy manager, or as listed here, the case coordinator or volunteer supervisor. And then there's a certificate of service at the bottom that certifies that we have given a copy of this guardian ad litem report to all of the parties involved. It is then signed by our program attorney and filed with the court. There are occasions when we don't need to file a full guardian ad litem report, and we will simply file what we call a memorandum to the court, and that will ensure that the judge has updated information for that particular hearing if there's something that we specifically want to address. This slide is a notice of filing for the guardian ad litem memorandum to the court. It's exactly the same as the guardian ad litem's notice of filing for the full guardian ad litem report, but this is the identifying information so that the parties are aware of which case this information has been filed on. The memorandum to the court is short and direct, straight to the point. You put the guardian ad litem case coordinator's name on it, the guardian ad litem volunteer, the type of hearing that the report is being filed for, and the date of the hearing. You indicate the child's current status, age, medical status, if there are any issues that the child is having, if the child is residing in foster care or within relative placement, if the parties are visiting consistently and how the child is handling that visitation. If the parent's visitation is occurring overnight, you have ensured that the child has adequate sleeping arrangements and all of the child's needs are being met. And then we have the parent status. That's where we talk about the case plan compliance and if the parents are doing all the things that they've been asked to do to remedy the problems that brought the case in. If they've been compliant with their assessments, if they're attending their classes, if they are testing negative for illegal substances, all of that needs to be outlined in the parent status. We tend to write what the recommendations are that the parents need to follow, and then how the parents are doing in following those recommendations. And then lastly, we put our recommendations. Because this is a very short report and all the information is very important to the court, then we ensure that we put the recommendations at the end. And we always start that paragraph with the guardian ad litem program respectfully recommends, because we're asking the judge to incorporate our recommendations in his order. And that's the time that we put what we like to see happen if the judge is in agreement with the recommendations that we make. Again, it's signed by the guardian ad litem volunteer, the guardian ad litem case coordinator, and the program attorney. In review, 3 very, very important items. You please visit your child monthly. Every child has to be seen at least once in every 30-day cycle. So it's very important that the children are seen at least once monthly. You ensure that you provide that information to your child advocacy manager via your child visitation form. And then the child advocacy manager and the volunteer will prepare that information in either a guardian ad litem report or a memorandum to the court, and that information will be provided to the court.